President, I know everybody's getting time here, but let me speak a little bit about one part of the bill. Tomorrow I'll be speaking about another part, but I strongly oppose the blanket grant of immunity that's contained in this bill. And I would hope senators would reject what is an ill-advised legislative effort to engineer specific outcomes in an ongoing federal judicial proceedings. Basically, we're telling another branch of government, here's the way you've got to come out in your decisions. Now, there is a way to cure that problem. Instead of the Congress telling the courts how they have to rule, we could adopt the Dodd-Feingold-Leahy amendment to strike Title II from the bill. This will strike the retroactive immunity provisions, but then it can lead to accountability for those who violated Americans' rights and violated the law. It will send a strong message that no one stands above the law in the United States. I'm not out to get the telephone companies. I just want us to know who it was in the administration said, go break the law. The American people ought to know who in the White House said, go break the law. Who it was who made the decision that somehow this president stands above the law. When you, Mr. President, know that, as I know, none of us stand above the law. The administration circumvented the law by conducting warrantless surveillance of Americans for more than 5 years. They're breaking the law. And then they got caught. The press reported this illegal conduct in the late 2005. Republican-controlled Congress didn't ask the questions to find out. The press found it out. Had they not done so, I have to assume this unlawful surveillance would still be going on today. When the public found out the government had been spying on the American people outside of FISA for years, the government and the providers were sued by citizens who believed their privacy rights were violated. They said, you're violating our privacy. We want you to be held accountable. But of course, that's why the founders created a system of federal courts through the Constitution. So people can assert their rights before a fair and a neutral tribunal without interference from the other branches of government. So they have somewhere they can go and say, I'm not a Democrat, I'm not a Republican, I'm not rich, I'm not poor, I'm an American, I'm seeking to have my rights upheld. Now, Title II of this bill would effectively terminate these lawsuits and those rights. It seeks to reduce the role of the court to a rubber stamp. So long as the Attorney General certifies that the government requested surveillance and indicated that it had been determined to be lawful, the cases are dismissed. Everybody's off the hook. It's not the court that says whether you follow the law. They say, oh, you're looking at us? We certify we followed the law. So therefore, you courts got to let us out the hook because after all, we said whether we broke the law or not, we said we're following the law, so we're home free. That's not a meaningful judicial inquiry. Mr. President, when I was a prosecutor in Vermont, that'd be like somebody's caught in a burglary and they said, but I've determined for me, the burglary laws don't apply, so you have to let me go. Nobody would take that seriously. We shouldn't take this. We shouldn't do something that doesn't give the plaintiffs their day in court. It is not just a heavy thumb on the scale of justice. It's a whole hand and an arm on the scale of justice, and I can't support it. If we look at the publicly available information about the President's program, it becomes clear that Title II is designed to tank these lawsuits, pure and simple, but then to allow the administration to avoid any accountability for their actions, whether they are legal or illegal. The Senate Intelligence Committee sent a report last fall that the providers received letters from the Attorney General stating that the activities had been authorized by the President and determined to be lawful. Guess what? These are precisely the magic words that will retroactively immunize the providers under Title II of this bill. The President, the fix is in. The bill is rigged based on what we already know to ensure the providers get immunity and the cases get dismissed. But it says that Mr. President, if you're in charge, you can just go out and break the law, and then when they look at you, send a letter to the court saying, I've determined that when I broke the law, I didn't really break the law, so you have to let me off the hook. Lewis Carroll once wrote a book about that. I think it was called Alice in Wonderland. So what if Americans' rights were violated? So what if statutes were violated? So what if those privacy-protecting statutes provided for damages? This bill makes our courts the handmaidens to a cover-up, and it's wrong. It tells the courts, the United States federal courts, it tells them take part in a cover-up. Mr. President, I can't support something that does that. It's wrong. Make no mistake. If Title II becomes law, there will be no accountability for this administration's actions in a court of law. We take away the only viable avenue for Americans to seek redress for harms to their privacy and liberties. And those who claim that American citizens can still pursue their privacy claims against the government, they know that sovereign immunity is a roadblock. They know that doesn't work. They know that cases against the government have already been dismissed for lack of standing. They know about the government's ability to assert the state secrets doctrine and various other legal defenses, protections for government officials. They know these suits will go nowhere. They know it is wrong for them to suggest otherwise. It's a red herring if there ever was one. The report of the Select Committee on Intelligence in connection with this earlier version of the bill that also included retroactive immunity is telling. The Select Committee on Intelligence wrote, the committee does not intend for the section to apply to or in any way affect pending or future suits against the government as to the legality of the President's program. And later wrote, Section 202 makes no assessment about the legality of the President's program. But neither that bill nor this one makes any allowance for such suits against the government to proceed to a decision on its merits. That is exactly and precisely what's lacking in this measure, an avenue to obtain judicial review and accountability. Now, those who support retroactive immunity for the telecommunication carriers and dismissal of the suits against them without providing an effective avenue to challenge the program or obtain judicial review of its legality, well, what they're doing, they're supporting unaccountability, pure and simple. They're saying everybody's off the hook. Everybody's off the hook. I'm not out to get the telephone companies. All I want to know is who in our government says go ahead and break the law. And this bill is going to make sure we never find out. In fact, the case that did proceed to decision in the federal court in Michigan was appealed by the government, is vacated, as dismissed for lack of standing. So the judicial decision on the merits that the President's program of warrantless wiretapping of Americans was a violation of law and the Constitution that is effectively wiped from the books. I note again, the proponents of this retroactive immunity have not and cannot say that the administration acted lawfully. They don't say the administration acted lawfully because they know the administration did not act lawfully. Even if one believes that the telephone companies merit protection, there is simply no good reason why Congress must act now to deal with the issue of the ongoing lawsuits against providers. The claims that these lawsuits will somehow bankrupt the providers is belied by the record demonstrating the financial health of these companies today, despite the ongoing litigation. Even the most alarmist critics of the lawsuits acknowledge it will be years, and probably at least 2 trips to the U.S. Supreme Court before we have any enforceable final judgment. And if there is such a risk, well, what does that say? It says that there were violations and that people's rights were violated. Now, I've said before that I support the government stepping into the shoes of these defendants, of these telephone companies, if we want to protect them. It's an easy way. If you're that concerned about the telephone companies, exclude them. Substitute the U.S. government. But we should not protect them if the cost of protecting them is all accountability and the cost of never getting a judicial determination on the merits of the cases whether the government violated the law. Americans have a right to know. Mr. President, I'd ask for an additional 30 seconds.
Without objection.
I believe the rule of law is important. I trust our courts to handle even the most difficult and sensitive disputes. That's the court's role in our constitutional scheme. Title II of this bill would have Congress decide these cases by legislative fiat. We don't want to diminish our federal judiciary and risk selling out large numbers of Americans whose fundamental rights may have been violated. We should not pass this. We should support the Dodd-Feingold-Leahy amendment. I yield the floor.